All right, today we're jumping into a piece of law that really affects every single person in Trinidad and Tobago. It's called the Criminal Law Act. We're going to break down what it is, why you should care, and how it impacts your rights and even your responsibilities as a citizen.
So let's kick things off with a question. Think about this. What happens when you have laws on the books from way back in 1936, but you're trying to apply them to today's world? It doesn't always work, right? Laws aren't set in stone. They have to change with the times. And sometimes that means a complete overhaul is needed to keep things fair and relevant.
And for Trinidad and Tobago, that big overhaul is this act. A great way to think about it is like a massive software update for the country's legal system. The whole point was to clean things up, make the rules clearer, and modernize a bunch of stuff that was just, well, old and complicated.
Okay, let's dive into our first section, Trinidad's criminal law update. We're going to start with one of the most fundamental changes the Act made. I mean, it changed the very language the law uses to talk about crime. So before this Act, the system had everything split into two big buckets. You had felonies, those were the really serious crimes, and then you had misdemeanors for the less serious stuff. But this wasn't just about different names. It meant different rules, different punishments. Honestly, it just made things super confusing for everyone.
And then, bam, Section 2 of the Act comes in with this incredibly simple but powerful line. With just one sentence, a legal tradition that was centuries old was just gone, wiped from the books. No more felony, no more misdemeanor. It was a game changer for simplifying the whole legal landscape.
So what did that leave us with? A single, simple category: offense.
Section 2, no more felonies. So if we got rid of the word felony, you might be wondering, well, how do we know which crimes are serious? Like, serious enough for an arrest without a warrant? That's a great question. And the Act set up a brand new way to figure that out. And it did that by introducing a new term you absolutely need to know: arrestable offense. The definition in Section 3 is super clear. An arrestable offense is any crime where an adult could get 5 or more years in prison. That's the new line in the sand. This is the benchmark for a lot of the serious powers we're going to talk about. Okay, so who can actually make an arrest for these arrestable offenses without needing a warrant? The law is very specific here, and it draws a really important line. For any regular person, you, me, anyone, you can make an arrest if you reasonably suspect someone is in the act of committing one of these crimes, right then and there. But police officers have a bit more leeway. They can make an arrest if they suspect an offense has already happened or is even about to happen. This, of course, leads to the next big question. What about using force? Section 4 says you can use force that is reasonable in the circumstances to stop a crime or help with a lawful arrest. And I want you to focus on that word reasonable. That's the key. Everything hinges on what's considered reasonable, and that's what gets decided in court. Okay, let's shift gears to something really heavy, one of the most complex parts of this law. Here's a question for you. Can you be guilty of murder, even if you didn't kill anyone? It sounds crazy, but the law has a very clear, and for some, very surprising answer.
The answer is something called constructive malice, which you'll find in Section 2A. Here's what it means in plain English. If a group of people are committing a violent, arrestable offense, let's say an armed robbery, and in the process, someone dies, everyone who was part of that robbery can be on the hook for murder.
Think about how wide that net is. We're not just talking about the person who pulled the trigger. We're talking about all the accomplices, anyone involved in that initial violent crime. It even applies if a death happens while someone is trying to resist a lawful arrest. The message from the law is pretty stark. If you get involved in this kind of dangerous crime, you share the blame for the worst possible outcome.
Okay, on to our next section, arrest, powers and limits. So we've talked about the power to arrest someone, but what about after the crime is over? The law is also really clear about what you can't do, and a big one is helping a criminal get away. Section 5 breaks this down really clearly with a kind of tiered system of penalties. Basically, if you knowingly help a criminal hide or escape, the punishment you face depends on how bad their crime was. Look at this. If you help someone who committed a capital offense, that could be 10 years in prison for you. And it goes down from there. But even helping someone who committed a lower-level arrestable offense can get you up to 3 years. The law does not take this lightly. And it doesn't stop there. Section 6 adds another layer. It's a crime to take money or anything of value to keep quiet about a crime you know about. The penalty for that? Up to 2 years in prison. The bottom line is simple. The law says you can't profit from crime by staying silent.
And speaking of giving information, what about giving false information? The Act covers that too. Wasting police time is a big no-no. If you knowingly file a false police report, you're looking at a $1,000 fine and potentially 6 months in jail. So they take that very seriously. Okay, so our next section is don't help, don't hide. And this whole idea of being responsible for your own actions doesn't just apply to helping criminals. The Act also used this principle to get rid of a really old, outdated legal idea that let one spouse kind of hide behind the other. Check this out. There used to be this old rule that said if a wife committed a crime while her husband was right there, the law just assumed he was forcing her to do it. It was just an automatic assumption. Well, Section 7 of the Criminal Law Act completely threw that out. Now, a wife can still make the case that she was coerced, but it's not assumed anymore. She has to actually prove it. And this is way more than just some legal technicality. It signals a huge shift in how society and the law views marriage. It moves away from outdated ideas and says, nope, both people in a marriage are individuals, and each one is responsible for their own choices and their own actions. All right, our last section here, an end to old rules. As you can probably tell by now, a huge theme of this act was sweeping away the old to bring in the new. So let's just do a quick recap of the biggest modernizing changes we talked about. So what are the big takeaways? First, crime categories got way simpler. No more felony and misdemeanor, just one category. Second, the act gave us clear rules on who can arrest someone and when, based on that key idea of an arrestable offense. Third, it made it crystal clear that helping or hiding a criminal comes with serious jail time. And finally, it got rid of some really outdated legal rules to better match how we see the world today. So there is no doubt this act was a massive leap forward in making the criminal justice system in Trinidad and Tobago clearer and more modern. But it leaves us with one last thought. Laws always have to keep evolving, right? They have to keep up with society. So that makes me wonder, looking around today, what's another old rule or outdated law that you think is ready for an update?